Gerrymandering is as old as the country itself. Although it's now pronounced gerrymander, it's named for Elbridge Gerry, a founding father twice elected governor of Massachusetts, and it refers to electoral districts that are drawn to the advantage of the party in power. Gerry was said to have drawn a district so twisted it resembled a salamander, which the daily papers renamed a gerrymander. States generally redraw electoral districts every 10 years following the national census. There are constitutional and statutory limits on how districts can be drawn. For example, the court has held that the Constitution requires one person, one vote. For any elected body, all districts must be about the same population. Also, the Constitution forbids using race as a predominant factor in redistricting, or in districting, and the 1982 amendments to the Voting Rights Act prohibit drawing election districts in a manner that has racially discriminatory impact. But political gerrymandering has proven a much more difficult question for the Supreme Court to address. In Davis versus Vanderbilt in 1986, the court held that partisan gerrymandering violated the Equal Protection Clause of the 14th Amendment, where there was substantial vote dilution, but did not provide a standard for determining this. Nor could it find an acceptable answer to that problem when it revisited the issue in 2004 in Veith versus Jubileer. In a 5-4 decision this year, a 4-justice plurality concluded that challenges to partisan gerrymandering are non-justiciable political questions because of the lack of a judicial standard to determine when there is a constitutional violation. Justice Kennedy, the 5th justice in that majority, concurred with the plurality but said he believed a manageable standard for judging the cases might still be developed, and challenged the lower courts to find one. This term, the court decided 3 cases that involve gerrymandering in different ways. We'll tell you about 2 of them.
In Gill versus Whitford, the court again addressed the question of the judiciability of political gerrymandering. In 2012, Republicans won 60 out of 99 seats in the Wisconsin State Assembly, with only 48% of the statewide vote for Assembly candidates. In 2014, they won 63 of the 99 seats, with only 52% of the statewide votes. Plaintiffs in the district court claimed the state's electoral districting plan was unconstitutional political gerrymandering. They charged the Republicans with what is called cracking and packing. That is, dividing a party's supporters among multiple districts so they can't form a majority in any of them, or concentrating the opposing party's members into a few districts so that they had far more voters than they needed to win in those districts and the extra votes were wasted. The 3-judge district court panel found for the plaintiffs, and the Supreme Court granted cert on the question of whether federal courts may hear challenges to partisan gerrymandering, and if so, when it violates the Constitution. So, Suzanna, did the justices finally decide these issues after all these years?
Not yet. Chief Justice Roberts wrote an opinion for a unanimous court saying that the plaintiffs lacked standing. He said that in order to have standing, plaintiffs have to allege a concrete and particularized injury to themselves. And so the plaintiffs in this case had argued that what harmed them was that the district boundaries were manipulated in order to keep Democrats statewide from having the same opportunities provided to Republicans to elect representatives to the Assembly. And the Chief Justice described that equal protection claim as one that their votes had been diluted compared to other voters in Wisconsin, but the problem was they didn't have any evidence of harm to themselves, only of statewide evidence. And so none of the plaintiffs had standing because none of them had shown enough harm to themselves.
Although the court held that the plaintiffs failed to establish standing by proving their injury, the court didn't dismiss the case. That, of course, is what usually happens when a court finds a lack of standing. But Chief Justice Roberts, writing for the court, said here, this is an unsettled claim. The contours of the right are uncertain. Justiciability is unclear. So the court remanded the case back to the 3-judge federal court to let the plaintiffs prove their standing.
Well, There was another sort of unusual aspect to this decision, and that was the concurrence by Justice Kagan. Tell us about that.
Well, yeah, there were two interesting wrinkles in her opinion. It was a concurrence. She said several times in her opinion that she was joining the majority in full, but she used the concurrence to suggest how the plaintiff on remand might actually prove the requisite personal injury by proving that he or she had lived in a district that had been packed or cracked. So, for example, the plaintiff could provide an alternative redistricting map that showed a way that his or her own district could be drawn in a way that avoided packing or cracking. And as she pointed out, the plaintiffs should already have this information, but they just needed to present it on an individual district by district basis instead of on a statewide basis.
I agree with Suzanna. I think Justice Kagan very much here was trying to provide a roadmap for the plaintiffs on remand. She did so, just as you say, with regard to standing, but she also did so with regard to the claim. She said to the plaintiffs on remand argue a First Amendment claim that the gerrymandering interferes with First Amendment political association. So this is different than a vote dilution claim under equal protection. Standing is easier to establish here. I think the conventional wisdom has been that she was trying to tell the plaintiffs what to do to best appeal to Justice Kennedy when the case would come back before the Supreme Court. But of course, he's no longer on the bench, and we'll see how it plays with the new justice.
Okay. Our second decision involving redistricting was Abbott versus Perez, involving both state and federal electoral districts in Texas. The case had a long procedural history, which isn't necessary to review in its entirety, but briefly, a three-judge federal district court in Texas found that the state legislature intentionally discriminated against Latino voters in 2011 when it drew electoral districts following the 2010 census. The three-judge court replaced the legislature's plan with one of its own, which then the legislature adopted in 2013 with few changes. But the plaintiffs in the 2011 case challenged that plan as well because they claim the legislature had not engaged in a deliberative process to ensure that the 2013 plan cured the discriminatory taint of the 2011 plan. The three-judge court found 3 districts in the 2013 plan violated the Voting Rights Act, and then a 4th district involved unconstitutional race discrimination. So, Erwin, where did the Supreme Court come down on this case?
The Supreme Court largely reversed the 3-judge federal court. It found that only one of the districts violated the Constitution or the Voting Rights Act. The Supreme Court stressed that the burden of proof is on the challengers to show a violation of the Constitution or of the Voting Rights Act. It said here there has to be a strong presumption in favor of the districting done by the legislature. The court said it's impermissible to impute bad motives for the 2013 districting based on what had happened in 2011. The court said that the 3-judge federal court erred by putting the burden of proof on the government to show that it wasn't violating the Constitution or the Voting Rights Act.
And then the court actually talked about the standard that would be applied when the plaintiffs had to prove their case, and the court applied the so-called Gingles factor from the decision in Thornburg versus Gingles. I believe we have those factors on the screen. These are that the plaintiff must establish first, a geographically compact minority population sufficient to constitute a majority in a single-member district. Second, political cohesion among members of the minority group. And 3, a block voting by the majority to defeat the minority's preferred candidate. If a plaintiff makes a showing that those 3 have been satisfied, then the plaintiff has to prove by a totality of the circumstances that the district lines in question dilute the votes of members of the minority, and the justices found that the plaintiffs had not satisfied the requirements.
The court did find that one of the districts was improperly drawn, House District number 90, and interestingly, the court there said that race was impermissibly used as a predominant factor to benefit Latino voters.
There was a long and vehement dissent in this case, wasn't there? Can you tell us about that?
Justice Sotomayor wrote the dissent. She criticized the majority for not giving sufficient deference to the fact-finding of the 3-judge federal court. But most of all, she was concerned for what this will mean for minority voters in Texas and other states around the country.
Finally, Husted versus A. Philip Randolph Institute was not about redistricting or gerrymandering, but looked at the interpretation of 2 federal statutes focused on voting and possible voter suppression. These are the National Voter Registration Act, or NVRA, and the Help America Vote Act, or HAVA. Both laws tell states that they must make an effort to remove ineligible voters from state voting rolls and details how they're allowed to do that. Under the NVRA, a state may not remove a voter's name from the rolls because of a change of a residence unless the voter either confirms in writing that he or she has moved or fails to return a pre-addressed postage-paid return card containing statutorily prescribed language, and the voter then fails to vote in any election during the period covering the next 2 general federal elections, which is roughly a 4-year period. NVRA also includes what's called a failure to vote clause that says a state removal program shall not result in a person's removal from the roll solely for failure to vote. Among other things, HAVA added language to this failure to vote clause, specifying that it doesn't prohibit the state from using the procedures of sending a return card and removing voters who fail to return their card and then fail to vote for the requisite time period. Husted was an action that was originally brought against the state of Ohio. So what was the complaint in Ohio?
Well, let me start by telling you what Ohio did. Ohio basically follows the letter of both federal laws. It sends out the requisite return cards, and if they are not returned, it waits 4 years and removes the voter only if the voter hasn't returned the card and hasn't voted in those subsequent 4 years. The problem is that the federal statutes don't specify what may or should trigger the sending of the return cards. So what Ohio does is it sends out the cards if somebody hasn't voted for 2 years. Other states do similar things. They might pick different time periods, but they send them out if someone hasn't voted. Still, other states just send them out at regular intervals, regardless of whether the voter has voted. And the challengers in Husted claimed that sending out the return cards on the basis of a failure to vote violated the failure to vote clause in the federal laws.
The Supreme Court ruled 5-4 that Ohio was not violating the National Voter Registration Act. The court said that the National Voter Registration Act says a state cannot remove voters from rolls solely for their failure to vote. The court said Ohio wasn't doing that, and thus no violation of the statute.
Well, Justice Sotomayor's dissent was again very strong. She said the majority opinion ignored the history of the voter suppression against which the NVRA was enacted.
I have to say that I'm a little bit surprised by the dissent and by the fact that there were 2 judges on the Sixth Circuit panel who agreed with the Supreme Court dissent. Ohio seems to me to have followed the federal statutes exactly and had been doing so for more than 20 years. I do think that this is just another indication of how sensitive the issue of voting and potential voter suppression has become.
I think it's important to put the 3 cases together that we've talked about. I think it shows a court that's going to give great deference to the states with regard to elections, whether you're talking about partisan gerrymandering, or even the use of race, or when to remove people from the voter rolls.
Thanks, Erwin. Next, a look at decisions affecting the federal courts.
The Supreme Court's decisions affect nearly every aspect of life in the U.S., but probably none more directly than the federal courts themselves. The rules by which the lower courts function, the nature and extent of their authority, and their relationship to other players in our constitutional system were all considered by the justices this term. Our next case, China Agritech versus Resh, involves several of these issues. When a class action suit is filed, it might take the courts to decide whether the class should be certified some time. And if a court not only takes a long time, but decides against class certification, the statute of limitations may have run out on the individual claims. So what happens then, Suzanna?
Well, the court answered that question in 1974 in American Pipe and Construction Company versus Utah, and then clarified its holding 9 years later in Crown, Cork, and Seal Company versus Parker. Essentially what the court ruled is that if that the filing of a class action stops the statute of limitations running for individual members of the class, so that if certification is denied, individual class members then have whatever time is left on the statute of limitations from the time that the class certification request was filed, and they can file an individual action within that time period, or they can intervene in another lawsuit during that period. The purpose of the rule, the court said, was to promote judicial efficiency, because if the rule went the other way, what would happen when a class certification request was filed is that individual members of the class would also file their own lawsuits just in case certification was ultimately denied, and that would clog up the courts.
Well, if the issue was dealt with decades ago, why was it here? Why were we revisiting it in China Agritech?
In American Pipe and in Crown Cork and Seal, it was a class action that was denied certification, and then individuals filed claims that would have otherwise been time-barred. In this case, the court denies certification of class action, but Michael Resh wants to file another class action suit that would be time-barred. The district court said that that was impermissible, but the Ninth Circuit reversed and said, just as individual claims can be filed when they're time-barred, so should we allow another class action suit to be filed.
So what did the Supreme Court say?
The Supreme Court reversed the Ninth Circuit here. Justice Sotomayor wrote for the court, joined by 8 justices. She said, though individuals can file a suit when class certification is denied, even though the individuals are time-barred, it's different when it comes to a class action being filed when it's time-barred, when class certification is denied. She says, when it comes to individual suits, there's the efficiency argument that Suzanna made. She said, when it comes to class action suits, it's very different. So when it comes to class action suits, we want people to come forward early so as to be able to determine who's going to be the class representatives, who's going to be class counsel.
She also pointed out that if the rule went the other way in this case, it would allow the statute of limitations to be extended essentially indefinitely. Every time class certification was denied, some other putative class member would be able to come forward and file another class action. Also, I think this case is not very surprising. The court has been cutting back on class actions generally, and we're going to see this again when we get to the Epic Systems versus Lewis case.
Our next decision is also about the tolling of a statute of limitations, but in this case, state, not federal statutes are in question. The case is Artis versus District of Columbia. Federal courts have supplemental jurisdiction over state law claims that arise from the same matter as federal law claims the court is adjudicating. The courts are given that authority by 28 U.S.C. 1367. If the federal court dismisses the federal claims, it can and often will dismiss the state law claims. The plaintiff can then refile the state law claims in state court. But what if the state statute of limitations has run out while the state claims were pending in federal court? Well, Section 1367D says the period of limitation for any state claim that's being heard with a federal claim in federal court is tolled while the claim is pending in federal court, and for a period of 30 days after it is dismissed, unless the state law provides for a longer tolling period. So what's the issue here, Erwin?
The issue is, what does the word tolled mean? Does it mean that the state statute of limitations stops running while the state claims are pending in federal court? Or does it mean that the state statute of limitations is running, but after the federal court dismisses the state law claims, there's then a 30-day grace period to refile those claims in state court?
And here's how it arose in this case. Stephanie Artis was fired from her job with the District of Columbia, and she sued in U.S. District Court under both federal law and D.C. law. The District Court eventually dismissed both her federal claims and her state law claims, and then she filed her state law claims in D.C. local courts 59 days later. And the D.C. courts took the approach that it was only a 30-day grace period, and therefore Artis's complaint was time-barred. She argued in front of the Supreme Court that tolling meant suspending the statute of limitations altogether during the pendency of the lawsuit, and that would mean that she had filed within the time limit.
So, Suzanna, what interpretation of the term tolling did the Supreme Court think was proper?
They agreed with her. They said that tolling means that the clock stops running altogether from the time the case is filed in federal court until 30 days after the federal dismissal. So Ardis's claim was timely. So what the majority looked at was they looked at the history of different interpretations of the term tolling, and they looked, of course, at dictionaries, as they often do, and they quoted an earlier Supreme Court decision, and then they said that the D.C. Court's atypical definition of tolling was, as they said, a feather on the scale against the weight of decisions in which tolling means stopping the clock.
Okay. So, but there was a second issue in this case too, and that was about the constitutionality of 1367D and whether really Congress could suspend state statute of limitations in the way that statute did.
The court found this an easy issue that had been previously resolved. The court said Congress had the authority under the Necessary and Proper Clause to adopt Section 1367. The court said this was previously decided in Jinks versus Rickland County.
Wilson versus Sellers also involved the relationship between federal and state courts, but this time the focus was on when federal courts can grant habeas relief on state court convictions. Susanna, can you fill us in on the background of this case?
Well, as our audience probably knows, Section 2254D prohibits federal courts from granting a writ of habeas corpus on a claim that's already been considered by a state court unless the state court ruling is contrary to or an unreasonable application of clearly established federal law. But that leaves open the question of what should happen if the last state court ruling, usually the state Supreme Court, doesn't give any reasoning or explanation. It simply denies review or affirms a lower court ruling. How is a federal habeas court supposed to decide in that case whether the state Supreme Court's ruling was either contrary to or an unreasonable application of federal law?
So how did this arise in the Wilson case?
Marion Wilson was convicted of first-degree murder and sentenced to death in Georgia State Trial Court. Subsequently, he files a state habeas corpus petition arguing ineffective assistance of counsel. The state trial court rules against him. The Georgia Supreme Court denies review. Wilson then files for habeas corpus in federal court alleging ineffective assistance of counsel. The federal court focused entirely on the state court decision with regard to the state habeas petition. The federal court finds that counsel's performance was deficient, but there wasn't prejudice, so there wasn't ineffective assistance of counsel. The 11th Circuit, though, says that the federal district court was wrong to look through the Georgia Supreme Court and focus just on the Georgia trial court. The 11th Circuit said it's also appropriate to focus on the arguments that the Georgia Supreme Court could have considered in support of the result.
And the justices disagreed with the 11th Circuit by a 6-3 majority. They held that a federal habeas court should look through an unexplained state court decision to the last state court decision that does provide a rationale. It should then presume that the unexplained decision adopted the same reasoning, but they were careful, the court was careful to note that the state can rebut that presumption by showing that the unexplained affirmance relied, or at least likely relied, on some different grounds.
It's important to note here that all of the other circuits had said that it is permissible for a federal habeas court to look through a court that didn't take the case and focus on the trial court that, or whatever court handed down the last decision. There's a real efficiency gain here because it lets the federal court focus on the actual decision that was rendered rather than try to imagine what arguments might have been made but never were advanced.
We should note, though, that the court explicitly said that the very unreasonableness of the lower state court decision could be some evidence that the higher unexplained decision actually didn't rely on that lower court decision, and that the state would have to come forward with some other evidence to rebut the presumption. So I expect that counsel for the state in future habeas cases is going to be making arguments and looking for reasons for why a state Supreme Court probably didn't rely on the same rationale as a flawed lower state court case.
Okay. Finally, we want to tell you about a decision the court reached affecting how U.S. federal courts should interpret laws of other nations. The decision was in Animal Science Products versus Hebe, Wellcome Pharmaceutical Company. U.S. purchasers of vitamin C from the Chinese company Hebe brought an antitrust suit against it for price fixing. Hebe responded that Chinese law required them to engage in price fixing, and they were therefore immune from U.S. antitrust laws. Hebe moved the district court to dismiss the case on those grounds. The Chinese Ministry of Commerce filed an amicus brief supporting Hebe's claims about Chinese law. The district court denied Hebe's motion to dismiss and held that Chinese law did not require the sellers to fix prices. The case was tried to a jury, which returned a verdict for the U.S. purchasers. The Second Circuit Court of Appeals reversed that decision on the ground that the Chinese ministry's interpretation of Chinese law was binding and that the district court should have granted the sellers in limine motion to dismiss the complaint. But the Supreme Court reversed the Second Circuit, holding that a federal court should carefully consider a foreign state's views about the meaning of its own laws. But a federal court is neither bound to adopt the foreign government's characterization nor required to ignore other relevant materials. Under Federal Rule of Civil Procedure 44.1, the court said a lower court should consider any relevant material, including its own research, to determine the content of foreign law.
We'll be back in a moment with a look at some federal statutes the court considered this term. Some of the most important work the court does every term is in interpreting federal statutes. This term, the court decided several cases dealing with a broad range of topics, both domestic and foreign. The first of these, Epic Systems Corporation versus Lewis, may have a profound effect on enforcing worker protections in a number of areas. Epic was actually one of three cases consolidated for argument that deal with the same question. Are workers who signed employment agreements with mandatory individual arbitration clauses allowed to file class action lawsuits against their employers? The companies argued that the courts have to uphold the agreements the employees signed under the Federal Arbitration Act, or FAA. The employees argued that their right to collective bargaining and organizing under the National Labor Relations Act, or NLRA, trumped the FAA. What did the court hold, Laurie?
Well, the court held in favor of the employers, saying that they could require the employees to settle the individual disputes through individual arbitration rather than coming together in a collective action to bring their claims. The 5-justice majority here said that the language of the NLRA does not bar enforcement of the arbitration agreements under the FAA. They said the NLRA has never been interpreted in its 77 years of existence to nullify the FAA, and that this court has never read a right of class action into the FAA.
The specific conflict between the two statutes, according to the employees, arose from Section 7 of the NLRA. That section protects workers' rights to unionization and collective bargaining, and also, in the language of this section, to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And the majority said that the other concerted activities were only those related to union organizing, and class actions have nothing to do with union organizing.
And the majority said that the FAA requires respect for arbitration agreements that are reached between private parties, that this might be different if there was some evidence of fraud or coercion that might invalidate the agreements, but that wasn't here. And they dismissed the employees' argument that the court should find in their favor based upon the so-called Chevron doctrine, which would say that the court should defer to agency interpretations if there's ambiguity in the statutes. The NLRB, National Labor Relations Board, which enforces the NLRA, had ruled back in a 2012 administrative action that the NLRA trumped the FAA. The majority dismisses that argument with very little analysis.
Laurie, what's the likely impact of this decision?
Well, most certainly it is going to make it more difficult for employees to bring workplace complaints, especially in cases of discrimination and sexual harassment. Frankly, it will cost the individual employees much more to litigate these claims than they're likely to recover even if they win.
There was an impassioned dissent read from the bench by Justice Ginsburg in this case, wasn't there, Suzanna?
Yes. She said that requiring adherence to arbitration takes away the employee's bargaining power. The employee's strength is in their numbers, and she reads Section 7 of the NLRA as written to protect employees who want to join together in collective litigation as well as other collective actions. She's essentially arguing for a broad interpretation according to the purposes of the NLRA, that because if the employees have a right, the employees must have a right to litigate collectively, and therefore waivers of their right to do so are unlawful. She also pointed out that the majority decision could lead to inconsistent and anomalous results in individual arbitration decisions, even where there were similarly situated employees.
Okay. The decision in Murphy versus Smith won't affect as many people as the decision in Epic, but it could have a significant effect for the smaller population it concerns. The question surrounds some ambiguity in the language of the Prison Litigation Reform Act of 1995. That statute says that when a prisoner wins a civil suit against a prison or a guard and the district court awards the prisoner's attorney's fees, a portion of the prisoner's judgment, not to exceed 25%, shall be applied to satisfy the amount of the attorney's fees awarded against the defendant. If the award of attorney's fees is not greater than 150% of the judgment, the excess shall be paid by the defendant. So, Suzanna, what was the ambiguity here?
Well, we should start by explaining what happened in this case. The petitioner here, Murphy, was a victim of a vicious assault in prison. He won a lawsuit against 2 guards, and he got about $300,000 in damages and a little over $100,000 in attorney's fees. And the judge ordered that 10% of his damages should go towards satisfying the attorney's fees, and the defendant would have to pay the rest of the attorney's fees. But the defendant argued that under the statute, Murphy should have to pay the full 25% of the attorney's fees out of his damages. And the ambiguity was whether the 25% amount stated in the statute was a ceiling or was a requirement, essentially asking whether the judge has the discretion to award a different amount than 25%. Okay.
So how did the court come down on these questions?
Well, Justice Gorsuch wrote for the majority that the prisoners who were successful in their civil rights suits must give, if necessary, 25% of their award to cover attorney's fees, and that trial judges do not have the discretion to apportion the fees. His reasoning, when the statute says a portion of the judgment not to exceed 25% shall be applied to attorney's fees, that obligation is mandatory, and the phrase to satisfy the amount of the attorney's fees means to discharge the obligation in full.
So there was a dissent that sort of just came down, argued the same as what the Third and the Eighth Circuit had previously decided. Can you tell us about that?
Yes, Justice Sotomayor wrote for herself and 3 colleagues that the phrase applied to satisfy meant that whatever amount is ordered paid toward attorney fees goes toward paying down the amount, but there is no mandatory 25%.
I think this is an interesting case because both the majority and the dissent had pretty plausible readings of the statute. It shows that even when Congress is trying to be clear, sometimes it doesn't succeed. So now the effect is, obviously the rule is detrimental to prisoners, but it does have the advantage of being a bright line rule. However, I think there's going to be more questions down the road. In this case, Murphy had a pretty large award, so taking 25% from him was still going to leave him a fair amount. But will a judge feel comfortable taking 25% of a much smaller award? Also, in this case, the Supreme Court is trying to limit the discretion of lower court judges, and that doesn't always work as well as the Supreme Court had hoped.
Well, there's not much discretion in what a judge must do to issue wiretap orders under the Omnibus Crime Control and Safe Streets Acts of 1968. The statute requires the judge to find probable cause to support the issuance of the order, as well as set forth in other detailed requirements regarding the application for a wiretap and the judicial order authorizing it. Suppression at trial is the price paid if any wire or oral communication was unlawfully intercepted, or if the order of approval under which it was intercepted is insufficient on its face, or if the interception was not made in conformity with the order of authorization or approval. Which one of these elements was in question in Dada versus United States, Laurie?
The argument in question in this case was insufficiency. Lose and Roosevelt Dada had argued that each of the 9 wiretap orders authorized to gather evidence against them on a drug conspiracy was insufficient on its face because each contained a sentence authorizing interception of information outside of the territorial jurisdiction of the authorizing judge. But here, a unanimous court, minus a recused Judge Gorsuch, disagreed with the Dadas. The court said that the wiretap orders authorized by the judge in Kansas were not facially insufficient. In fact, just because they included language that authorized outside of the district, insufficiency means something is missing. Here, Justice Breyer wrote for the court that the additional language was more surplusage, and the government didn't actually seek to use the calls outside of the district, so the additional information had not hurt anything.
The court recognized that there will be some hard questions. Lower courts may disagree on what kinds of defects are insufficient. It also discussed a hypothetical, imagining a wiretap order that authorizes 180 days worth of wiretaps, even though the statute limits it to 30 days. And the court said it wasn't deciding that question, but it hinted very strongly that only information obtained beyond the first 30 days would be suppressed.
In deciding how Jesner versus Arab Bank, the court revisited a federal statute that has dealt with repeatedly over the years and always with some trepidation. It's the Alien Tort Statute, enacted as part of the Judiciary's Act of 1789 and dealing with the rights of non-citizens to sue in U.S. federal courts. Jesner's consideration of the ATS produced one of this term's most fractured opinions. So, Laurie, tell us about the background.
A little bit on the background. The victims of some terrorist attacks in the Middle East countries sued the Arab Bank, which is a Jordanian corporation in the United States, claiming that it had funneled money to the terrorists. The victims argued that the ATS gives the U.S. federal courts jurisdiction over, quote, any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. In Jesner, the court acted to decide if only individuals could be sued or also corporations. That was their focus. And what resulted, frankly, was a plurality decision, 3 concurrences and a dissent. The bottom line, though, is that the ATS cannot be used to sue the foreign corporations in the United States courts for activities that take place outside of the United States.
Okay. So how did the court reach that decision?
Well, it reviewed the history of both the ATS and its own past decisions, focusing especially on Sosa v. Alvarez-Machine, in which the court had held that the Alien Tort Statute, as a jurisdictional statute, didn't create a cause of action.
And as Suzanna said, the plurality did apply the Sosa test for limited application of the ATS. And we have that up on the screen now. 1, can the plaintiff demonstrate that the alleged violation is, quote, of a norm that is specific, universal, and obligatory? 2, even assuming that, would allowing the case to proceed under the ATS be a proper exercise of judicial discretion in light of concerns over foreign affairs and separation of powers? Using that test, the court concluded that international law for human rights has not been extended to actions against corporations or other artificial entities, and that recent precedents of the court cast some doubt on the authority of the courts to extend private actions or private causes of actions even in the realm of domestic law.
Okay, and so the 4-justice dissent?
Yes, there was a dissent that said the plurality actually misunderstood international law, that if you look at the text, the history, the purpose of the ATS, that did support the idea that corporations can be sued under that law. They said that there are other limitations, perhaps, that the court could put on these actions against corporations, such as requiring the alien to sue in their home country first. And finally, the dissenters dismissed these political concerns in this case because the Solicitor General and the Congress actually supported the plaintiffs in their ability to sue.
Next up, federalism and separation of powers.
Federalism and separation of powers are arguably the two central tenets of the U.S. Constitution. Finding a balance between the power of the federal and state governments that would allow the new country to function more efficiently than it had under the Articles of Confederation was a reason for calling the Constitutional Convention in 1787. Once there, the chief challenge was devising a government that would allow each of its parts the effective power to do its job without overwhelming the others. Those two efforts continue to this day and presented themselves again this term at the court. The issue in Murphy versus National Collegiate Athletic Association, or the NCAA, was the authority of the federal government over state legislatures. In the 1990s, Congress passed the Professional and Amateur Sports Protection Act, or PASPA, which prohibited states from passing laws authorizing sports gambling. It also made it unlawful for states to advertise such schemes. PASPA did not make sports gambling a federal crime, but instead it allowed the Attorney General, as well as amateur and professional sports organizations, to bring civil actions to enjoin its violation. So how did it affect the situation in New Jersey, Erwin?
The federal statute required that states have laws to prohibit sports betting. It created an exception for 4 states that already allowed sports gambling. And it said New Jersey had 1 year from the time of the enactment of the federal law to decide whether to allow sports betting. New Jersey didn't do anything during that year. Subsequent to that, New Jersey voters passed an initiative to allow the legislature to permit sports gambling in New Jersey. New Jersey's legislature then enacted such a statute permitting amateur and professional sports betting. Federal district court said that's preempted by federal law. New Jersey, you had a year and you didn't take advantage of it. The Third Circuit affirmed, the United States Supreme Court denied review. Then the New Jersey legislature took a different approach. It repealed its existing law, the one that was on the books, that prohibited sports gambling. The federal district court said, this is still preempted. You had your year to allow sports gambling, you didn't do it. The Third Circuit affirmed. But the United States Supreme Court reversed and ruled in favor of the state of New Jersey. The Supreme Court said it's well established that it violates the 10th Amendment for Congress to commandeer state and local governments. In cases like New York versus United States and Prince versus United States, the Supreme Court said Congress cannot compel state governments, local governments to enact laws to enforce the federal mandate. And the court said that's exactly what Congress was doing here.
Essentially what the court said is that the difference between compelling a state to enact legislation and prohibiting it from repealing existing legislation is an empty distinction, and in both cases the Congress is violating the directive that Congress can't issue direct orders to state legislatures.
So what are the implications?
Well, one implication is any state that wants to now can allow sports betting on both professional and amateur athletics. I also think there's going to be implications for this decision for some cases now pending in the lower federal courts. President Trump issued an executive order that said that state and local governments that don't cooperate with immigration officials will lose their federal law enforcement funds. 3 federal district courts in San Francisco, Chicago, and Philadelphia have found that to be impermissible commandeering. The Supreme Court's strong endorsement of this anti-commandeering principle could be quite important for that litigation.
In South Dakota versus Wayfair, the question was the power of the federal government over the states in relation to interstate commerce. Previous decisions by the Supreme Court had prohibited states from collecting sales tax on businesses that sold goods in their states unless they had a physical presence there. Doing otherwise, the court ruled, would place an undue burden on the interstate commerce and violate the Dormant Commerce Clause. Facing an eroding sales tax base, and the loss of revenue to pay for state services, South Dakota passed a law requiring out-of-state sellers to collect and remit sales tax as if they had a physical presence in the state. Now, the law only covered sellers that delivered more than $100,000 of goods into the state annually, or engaged in 200 or more separate transactions for the delivery of goods or services into the state. Defending the law before the Supreme Court, South Dakota asked the justices to overturn two precedents in Dormant Commerce Clause jurisprudence. It argued that they had become outdated. Did the justices do that, Suzanna?
By a 5-4 majority, they did do that. The two prior decisions were Quill versus North Dakota and National Bellis Hess versus Department of Revenue of Illinois, and both of them were overruled. Justice Kennedy wrote the majority opinion. He said that Quill was wrong when it was decided and had become even more wrong over time because it created a tax haven for internet companies and it discriminated against local companies who had to pay the tax. He said it created a formalist artificial rule that bore no resemblance to current economic reality, and that it didn't even create a bright line with certainty because there was a lot of uncertainty about what constitutes a physical presence.
So did the decision lay down a new rule for when states could tax out-of-state companies?
No, the court did not lay down a new rule. Instead, Justice Kennedy's majority opinion said that we should rely on the test that was articulated in Complete Auto Transit versus Brady. The issue in that case was the ability of a state to tax out-of-state transactions. It's different than the precise issue in this case, which is about whether a state can force out-of-state businesses to collect sales tax. In Complete Auto Transit versus Brady, the Supreme Court articulated a four-part test for determining whether a state tax violates the Dormant Commerce Clause. I understand we have that four-part test on the screen. First, does the tax apply to an activity with a substantial nexus to the taxing state? Second, is the tax fairly apportioned? Third, the tax must not discriminate against interstate commerce. And fourth, it must be fairly related to services that the state provides. Of course, the key for future litigation is going to be the first prong of the test, whether there is a substantial nexus to the taxing state. And here, Justice Kennedy articulated the test that's been used before, and I understand that that's on the screen as well, where the court says, a substantial nexus is established when the taxpayer or collector avails itself of the substantial privilege of carrying on business in that jurisdiction.
Now, there was a dissent written in this case by the Chief Justice with a fairly unusual lineup, as was the majority. What was that, Suzanna?
Well, yes, it was quite unusual. The Chief was joined in his dissent by Justices Breyer, Sotomayor, and Kagan, and Justice Kennedy's majority included Justices Alito, Gorsuch, Thomas, and Ginsburg. So those are two lineups you don't see very often. The dissent's position was basically that the court should have applied stare decisis and upheld its precedents and essentially left it to Congress to solve the problem of whatever discrimination there was between internet companies and brick and mortar companies. The dissent also pointed out that while e-commerce had transformed the modern economy, e-commerce also developed under the rules of Quill and Bellis Hess, and that therefore taking away those rules might be quite disruptive.
Now, how important is this decision? What do you think the effect may be?
This case is going to be very important. It's going to be substantial additional sales tax revenue for state governments. Justice Kennedy pointed out that state governments were now losing as much as $33 billion a year in sales tax revenue that they can now collect. Also, I think, from the perspective of the federal courts, it's going to lead to a lot of litigation. The test is, what's a substantial nexus to the taxing state? I read the definition. It leaves so much ambiguity.
I agree. And what if a state enacts a law, unlike this one, that requires every seller out of state to collect taxes, even people who just sell a few things on eBay or on their own website?
Thank you. Our separation of powers decision is Lucia versus Securities and Exchange Commission. Under the Appointments Clause of the Constitution, officers of the United States, as distinct from mere employees of the federal government, may be appointed by the President, courts of law, or heads of department. The Securities and Exchange Commission, or SEC, has statutory authority to enforce the nation's securities laws. When it does this by instituting an administrative proceeding against someone, the Commission often delegates that task to an administrative law judge, or an ALJ. In overseeing one of these adversarial proceedings, the ALJ exercises an authority comparable to that of a federal district judge conducting a bench trial. And although the decision issued by the ALJ at the end of the proceeding is reviewable by the Commission, if the Commission decides not to do that, the ALJ's decision becomes final and is deemed an action of the Commission. But for all that authority, the ALJs at the SEC are selected by other employees of the Commission, not the Commissioners themselves. So how did the court come down on this issue?
The Securities and Exchange Commission began an investigation of Raymond Lucia. He had a retirement investment plan. He called it buckets of money. The administrative law judge found that he was in violation of federal securities law. Civil penalties of $300,000 were imposed on Lucia. Also, a lifetime ban on investment advice was imposed on him. He argued, though, that the appointment of the administrative law judge violated the Constitution. As you said, the ALJ was hired as an employee. He said that the ALJ should be treated as an office of the United States, so that under the Constitution, the appointment had to be either by the President or the heads of departments or the lower federal courts.
The majority actually didn't have much trouble with this question. The majority thought that 3 prior decisions pretty much answered the question of who's an employee and who's an officer. United States versus Germain stressed the idea of tenure and duration and made it clear that an individual must occupy a continuing position established by law to qualify as an officer. And then Buckley v. Vallejo later determined that members of federal commissions are officers rather than employees only if they exercise significant authority pursuant to the laws of the United States. So the focus of the inquiry is on the extent of the authority that an individual wields in a particular position.
So did the court then define significant authority in Lucia?
No, the court found it unnecessary to articulate a new definition. The court said in Freytag versus Commissioner, a definition had been announced. It's significant, unadorned authority. The court in that case found that the special tax judges were exercising significant, unadorned authority. The court said here there's really no difference between the administrative law judge and those special tax judges, and so that therefore this is somebody who had to be appointed by the President, the heads of departments, or the lower federal courts. And the court said there has to be a new proceeding against Lucia in front of somebody else who's been properly appointed.
So how significant do you think this decision is?
I think it's going to be significant. To start with, it's going to mean that administrative law judges throughout the federal government are either going to have to be appointed by the President, the heads of departments, the lower federal courts. Now, for the Securities and Exchange Commission, there's only 5 administrative law judges. But in the Social Security Administration, there's 1,500 administrative law judges. And either Congress is going to have to decide, or there's going to have to be some voluntary agreement to comply with what the Supreme Court has said requires. I also think this case is going to raise a major issue with regard to removal power. This is something that Justice Breyer identified. Once these individuals are deemed to be officers of the United States, then who can remove them? It's going to be a major question. It's going to be litigated a great deal in the future.
I think this case is also part of a larger reconsideration of this by this court of the administrative state. Already next term there's a case on whether particular broad delegations of legislative power are unconstitutional, and I think the signs are that we could see a significant challenge to the Chevron deference principle as well.
Thanks. We'll be back with some decisions dealing with criminal trials, pleas, and sentencing. Our next 2 decisions both address the meaning and application of the same federal statute, that is 18 U.S.C. section 3582, subsection C2. That law authorizes a district judge to reduce a defendant's sentence if, quote, the defendant has been sentenced to a term of imprisonment based on a sentencing range that has subsequently been lowered by the Sentencing Commission. The Sentencing Commission has lowered the sentencing guidelines range for most drug offenses and made these changes retroactive, leading to a large number of prisoners sentenced under the original guideline range to seek a reduction under 3582C2. The applicants in our next 2 cases were among them. Laurie, can you tell us about the first case, Hughes versus United States?
Yes, Hughes is the more complicated of the two cases. Eric Hughes was indicted on a drug conspiracy with drug charges and gun charges related to a conspiracy to distribute meth. And he agreed to what we call a type C type of plea agreement with the government. Hughes would plead guilty to 2 charges. The government would dismiss 2 other charges, and then the government would not file an information which would have made him subject to a mandatory life sentence. Type C are binding agreements under the Federal Rules of Criminal Procedure. And under the agreement, Hughes would serve 180 months, but the agreement did not refer to any particular guideline range. The district court accepted the agreement, and Hughes was sentenced to 180 months. Then after that, the Sentencing Commission later amended the guidelines, so Hughes would have been subject to about 3 to 4 years lower on the guidelines as applied to his crimes. Prosecutors ended up arguing that Hughes did not qualify for the reduction because he had a type C type of agreement, and it didn't refer to the guidelines at all. It only referred to the sentencing of 180 months.
So the question was, can a prisoner who agreed to a type C plea still get a 3582C2 reduction if the Sentencing Commission retroactively reduces the guidelines range for the crime he was convicted of?
And the Supreme Court said yes. They ruled in favor of Hughes here. The court said that a criminal defendant who takes a type C plea can take advantage of a reduction in the guideline range, where the trial judge relied on the guideline range, at least in part with regard to the sentence. Justice Kennedy wrote the opinion for the court here. He focused on the plain language of the statute. He also noted that here the trial judge had referred to the sentencing guidelines in imposing the sentence. I think this is important because it resolves some confusion in the Supreme Court. In Freeman v. United States in 2011, the Supreme Court had split 4 to 1 to 4 on this question. Also, Justice Kennedy said that proceeding in this way really serves the purposes of the sentencing guidelines, making sure that criminal defendants who have committed similar crimes are given similar sentences.
So this was a 6-3 decision with the chief writing in dissent. What did he say?
Well, the dissent said that type C sentences rely on the plea agreement, not the sentencing guidelines. And defendants who take this type of plea should not be eligible for those reductions under 3582C2. And the chief also imagined that in the future, though, prosecutors could get around this particular decision by adding provision to type C plea agreements that the defendant actually waives any right to seek the sentence reduction following a future guidelines amendment.
So, Erwin, can you tell us what happened in our next case, Coons versus United States?
Here, the Supreme Court rules in favor of the government and against the criminal defendants. What's important to note here is that it involves 5 criminal defendants, and their sentences were based not on the sentencing guidelines, but on federal statutes providing for mandatory minimum sentences. Now, they could have been sentenced under the guidelines, and the Sentencing Commission reduced the guideline range for their sentences. But the Supreme Court says when the criminal defendant's sentences were based on the mandatory minimums in federal law and not the sentencing guidelines, then the reduction is appropriate. In this instance, in fact, the defendants have given sentences less than the mandatory minimums because of the cooperation with federal law enforcement authority.
So, Laurie, what do you think are the implications of this decision?
Well, this decision, I think, provides some straightforward guidance for the lower courts in deciding on a reduction in the guidelines, whether it provides a basis for relief under 3582C2. The court has to decide whether the sentence was actually based on the guidelines or other considerations, and only sentences that are actually based on the guidelines would be eligible for the reduction under 3582C2.
The court also dealt with the issue of whether a defendant who is sentenced under the wrong guidelines range can object to that mistake on appeal if he didn't object in the district court. This was Rosales-Morales versus United States. When Florencio Rosales-Morales was sentenced for illegally entering the country, the probation office mistakenly counted a previous state misdemeanor conviction twice. That raised the guidelines range that he was sentenced under. Rosales-Morales didn't object in district court, but later objected to the error on appeal. So what were the appellate court's options under these circumstances?
Under Federal Rule of Criminal Procedure 52B, an error can be raised on appeal, even if it wasn't raised in the trial court, if it's a plain error and it affects substantial rights. In United States v. Solano, the Supreme Court articulated a four-part test for determining when such an error can be raised on appeal, even though it wasn't presented below. As I understand it, we have that four-part test on the screen. First, there must be an error that has not been intentionally relinquished or abandoned. Second, the error must be plain. That is, it has to be clear or obvious. Third, the error must have affected the defendant's substantial rights. And finally, fourth, if those three factors are met, the Court of Appeals should exercise its discretion to correct the forfeited error if the error seriously affects the fairness, integrity, or public reputation of judicial proceedings. What this case is about is the fourth of those factors.
And in this case, the Fifth Circuit found that the error was plain and affecting substantial rights, but declined to exercise its discretion to actually correct the mistake because it said that the error did not seriously affect the fairness or the integrity of the judicial proceedings. In order to do so, the circuit said it had to shock the conscience of the common man.
But the Supreme Court disagreed with the Fifth Circuit, didn't it? It found that standard too restrictive.
It did. In a 7-2 decision with Justice Sotomayor writing for the majority, the court held that an error in calculating the guidelines range is one that affects the fairness, integrity, and public reputation of the courts. In fact, the court specifically said that the proof of a plain guideline error that affects substantial rights satisfies that burden of persuasion, of showing that it affected the fairness, integrity, and public reputation of the courts. Now, the majority does say that while any exercise of discretion under Olano's fourth prong requires an individual case-specific inquiry, there were no countervailing factors in this case, and therefore it was satisfying the error.
I think this case can have practical implications. I think it will make it easier for criminal defendants to challenge their sentence on appeal, even if they didn't raise errors in the district court. I think the fact that the court rejects the shocks the conscience test maybe was most important in terms of practical effect. It's unclear, though, what it's going to mean beyond the sentencing context.
Okay, thank you. Before we turn away from the decisions dealing with the sentencing guidelines, we want to tell you about the court's decision in Chavez Meza versus United States. Chavez Meza was sentenced to a term at the very bottom of his sentencing guidelines range. When the Sentencing Commission later lowered the guidelines range for the crime he was convicted of, Chavez Meza sought a modification to his sentence based on the change. The judge lowered his sentence, but not all the way to the bottom of the new range, and Chavez Meza appealed on the ground that the judge had not adequately explained his reasons for choosing the new sentence. He also argued that the new sentence should have been at the very bottom of the new range. A 5-3 majority disagreed with Chavez Meza. Justice Gorsuch didn't take part in the decision because it originated in his former circuit. The majority looked back at some of its prior decisions and concluded that the record of the resentencing as a whole, including the judge's comments at the initial sentencing, supported the judge's decision not to impose a new sentence at the very bottom of the new range. The court did not, however, decide more broadly whether the obligation of explanation is the same at initial sentencing and at resentencing after a guidelines modification.
Next, Class versus United States poses an important question noted by Justice Breyer in his majority opinion. Does a guilty plea bar a criminal defendant from later appealing his conviction on the grounds that the statute of conviction violates the Constitution? A federal law prohibits having firearms in Capitol buildings or on Capitol grounds. Class was indicted for having firearms in his locked car on the grounds of the U.S. Capitol. He moved to dismiss the charges based on the Second Amendment and due process grounds, but the district court denied his motion. Then what happened, Erwin?
He then pled guilty to the federal charges. The plea agreement is important here. The plea agreement says there are certain things he still could raise later. He could raise a claim of ineffectiveness as a counsel. He'd be able to raise a claim based on newly discovered evidence. It also said there's certain things he couldn't raise. For example, he couldn't raise the statute of limitations. He couldn't bring a collateral attack on the conviction. The plea agreement said nothing, though, about whether he could bring an appeal based on constitutional arguments. He brought such an appeal to the D.C. Circuit. The D.C. Circuit said, though, that he had waived the ability to appeal on the constitutional issues by pleading guilty. The United States Supreme Court, in a 6-3 decision, reversed the D.C. Circuit. Justice Breyer wrote for the court and said that the guilty plea here did not preclude the ability to bring an appeal based on the constitutional challenges, the Second Amendment and due process.
And what was the majority's reasoning?
In part, Justice Breyer relied on prior precedents, that a guilty plea doesn't preclude the ability to challenge constitutional issues where the plea agreement is silent about it. Now, the government made the argument that Federal Rule of Criminal Procedure 11A2 was the sole ability to bring such a challenge. But Justice Breyer said there's nothing in the text of that rule that says it's the sole ability to bring such an appeal.
But folks, this is where it becomes messy, because the decision does not establish a per se rule that all constitutional claims can be brought after there's a guilty plea. Guilty pleas do waive some constitutional rights, such as Fourth Amendment challenges, challenges to the grand jury proceedings. In fact, a defendant may waive the right of appeal in a plea agreement. So the court ends up and says we look to 5 categories of what can be argued on appeal after a guilty plea. I think we do have those up on the screen. 1, certainly claims implicating the power of the state to prosecute the defendant. 2, claims that do not contradict facts alleged in the charging document. 3, claims that facts alleged and admitted do not constitute a crime. 4, claims other than case related to constitutional defects that occur prior to entry of a guilty plea. And 5, claims not contradicting a written plea agreement. So right now, when we look at the court's decision here and its precedent, it looks like the clearest grounds are that the court did not have jurisdiction, the statute of conviction was unconstitutional, double jeopardy, and finally, vindictive prosecution.
I think it's worth noting here that the dissent called this a muddle, and that it would limit appeals after guilty pleas to jurisdictional claims. Okay, now here is John Cooke with some final words.
That's our program for this year. We hope you found it interesting and useful. Please take the time to fill out the online evaluation form that you'll find on the same page as the written materials at our website. It's the only way for us to know how we can improve this program and make it even more useful for you in your work for the courts. I thank the faculty for helping to explain these decisions and everyone at the Federal Judicial Center responsible for producing this program. I'm John Cooke. Thank you for watching.